A number of types of organizations can hold conservation easements, broadly broken down into two categories: governmental entities and private conservation charities. Examples of public entities are the Virginia Outdoors Foundation, which holds many of the easements granted in Virginia, the Department of Forestry, or a local soil and water conservation district. Examples of private charities involved in the conservation easement process involve local land trusts, such as the Western Virginia Land Trust, which in particular instances may not only assist you in coordinating the easement, but may hold the easement themselves. There are also a number of large national charities involved in conservation easements. These would include the Nature Conservancy, Ducks Unlimited, as well as a number of other entities. Whom the holder of your conservation easement is going to be involves on the particular facts with respect to your property, the types of restrictions that you desire to place on your property, and how those two fit together. A conservation easement is an effective tool for a coordinated estate plan with regard to estate tax issues. If your estate is otherwise subject to federal estate taxation, the current value of which is $2 million, then the use of a conservation easement can effectively lower the value of the property in the estate, thereby reducing estate taxes. In addition, a qualified conservation easement is afforded special treatment. In a qualified estate, it can reduce the value of the remaining property by an additional 40%. This is a 40% in addition to the diminution in value which occurred when the easement was recorded, and can affect substantial additional savings up to $500,000 on the estate taxes that would otherwise be assessed against the property. Once the easement is recorded, can it be amended, changed, or revoked? Well, the short answer to that question is it is very hard. And if you think about it, you would want it to be. Once you have granted a conservation easement on your property, you want to make sure that it is enforced by the agency you granted the easement to and respected by future owners of your property. That is the whole point of doing the easement in the first place. Amendment or revocation requires a court order and can only be done in very narrow and specific circumstances that would involve a change of circumstance. To amend an easement is also difficult. If it is being made more stringent, the parties can agree to record an amendment to the easement adding additional restrictions. The difficulty comes if the easement is being amended to make it less stringent, and similar to revocation, it would in most cases require a court order as well as consent of the landowner and the agency holding the easement. Often I am asked, how does a conservation easement fit into my estate plan? Well, there are a number of ways where a conservation easement can assist a family in the preparation of a coordinated estate plan. Often the family's question is, how can one of my children afford to own this farm and continue farming? A conservation easement reduces the value of the farm due to the restrictions that have been placed on the property. This often makes it more affordable for one of the children to purchase the farm from the patriarch and afford to continue farming. Conservation easements also assist in estate planning by ensuring that your conservation values are continued on this property by your heirs and future purchasers of the property. If you are concerned that your children will divide the farm and sell it as a subdivision just as soon as you pass on, a conservation easement is an effective way to ensure that your values with respect to the property are continued by future owners. An important benefit of a conservation easement on your property, if it is held by the Virginia Outdoors Foundation or other state agency, is that condemnation of the property becomes extremely difficult. For instance, if a utility wanted to place a line or pipe through your property and the Virginia Outdoors Foundation held a conservation easement, they would have to go to the State Corporation Commission as two co-equal bodies to decide whether the condemnation could take place. In our experience, the result of this is that the utility company finds another way to place the line on someone else's property. One issue that sometimes comes up is property held in a revocable or irrevocable trust. If the property is held in a revocable trust during the lifetime of the creator of the trust, an easement can often be placed on the property without many issues. If the property is held in an irrevocable trust or a trust after the creator has died, you should seek the advice of counsel because there are additional important issues to be considered. One issue to consider when evaluating a conservation easement is if you or other close family members, brothers, sisters, parents, children, own property in the same general area as the property to be encumbered by the easement. If this is the case, then the appraiser will have to take into account any improvement or inurement to the adjoining property as a result of the conservation easement, and will have to take that inurement into account when determining the value of your easement. The enhancement in the value of the adjoining property is because it will now adjoin property that cannot be developed. It is similar to being adjoining to a public park or national forest property, and in some instances may make the adjoining property more valuable than it was before the easement was placed on your property. As we have discussed, involvement of counsel is important to the conservation easement process given the complexity and the number of options available to the landowner in the conservation easement process. I would urge you to involve counsel early in the process because this is a time-consuming matter, and as the process moves along, a number of decisions can be made which will permanently affect the negotiation process. I hope you have found the answers to some of these questions helpful as you evaluate a conservation easement for your property.